I'm back, guys, and I decided to read the Microsoft Windows Insider Program Agreement, just cause for the reading of the library's done a little reading program, and they put just read. So, yeah. So we're gonna read this for 20 minutes, kind of similar to my reading the Windows 10 EULA. And 3, 2, 1. Microsoft Windows Insider Program Agreement, posted October 2020, effective October 1st, 2020. It's effective mainly as posted, apparently. If you live in or your principal place of business is in the United States, please read the binding arbitration clause in class action waiver in section 15. It affects how disputes are resolved. Welcome to the Microsoft Windows Insider program. Our program gives volunteers, insiders, the opportunity to test drive experimental and pre-release software on your devices and participate in the program for free. We welcome your feedback to help us improve and make Windows an even better product for everyone. So we're excited to hear what you think. Before signing up, please carefully review all the product terms which create legal between you and Microsoft Corporation, or based on where you live, or if a business where your principal place of business is located, all of its affiliates. And government your participation in the program that once accepted by you applies to you. If you specify a company name and sign up for this program, that means you are entering into this agreement on behalf of that organization or company. If you are entering this agreement on behalf of an entity, such as your employer, you represent that you have the legal authority to bind that entity. By signing up to participate in the program, you represent that you are the legal age of majority where you live and agree to be bound by the terms of this agreement, which is required for you to participate in this program. Upon program participation, you are volunteering to participate in the program with the knowledge that the purpose of this program is access use to provide us with feedback relating to experimental, preview, beta, or other early pre-release software made available to you, including related documentation, materials, and information such as program web pages, emails, forms, content, feedback, and other services, program sources, for the purpose of providing Microsoft with useful information about experience with the software and program services. You understand that using experimental and early pre-release software means that you could experience occasional crashes and data loss. By participating, you acknowledge that it is your responsibility to frequently back up your data and restore it in the event of data loss. Your program participation is voluntary, free, and there's no compensation for your participation. Participation does not create a legal partnership and employment relationship between you and Microsoft. Your program is not obligated Microsoft to provide you with software program services. You agree not to decompile, reverse engineer, disassemble, decrypt, or otherwise attempt to derive the source code of any software except and only to the intent that the foregoing restrictions: A, permitted by applicable law; B, permitted by license terms governing the use of open source components that may be included with the software; or C, required to debug changes to any libraries licensed under GNC less for general public license, which are included with and linked to by the software. This program may be substantially different from the commercially released versions. Because the software may contain errors or inaccuracies, you should back up your device before installing any software. We recommend installing on non-production devices that are non-business critical because more likely to experience crashes, setting and policy changes, loss of data or apps, feature and functionality changes, cause other apps stop working, be updated or removed from your device automatically without notice, and there are potential issues. We recommend that you do not install on any system you don't directly control or that you share with others. Pre-release and experimental software and services. This program may not included. This program may have not included, reduced, or different security, privacy, accessibility, availability, and reliability standards relative to commercially provided services and software. We may change or discontinue the program at any time without notice. Recovery. To recover, you may have to reinstall your apps, the operating system, or refresh your device. Some instances, you won't be able to go back to your prior version of software. Automatic update. Program updates automatically. For example, for Windows Update, automatic updating cannot be turned off. Some features may be removed or may stop working at a predetermined time period or at the end of the validation cycle once enough data has been collected. Some third-party applications installed on the device may also not work, may stop working, or may be automatically deleted by the program. Support. Limited and no support may be provided for the program. Data and internet charges. Some of the program may require your device to access the internet. Your access and use, including charges, may be subject to the terms of your cellular or internet provider agreement. You are responsible for understanding and complying with the terms of your own plan's agreements, and any issues arising from using or accessing networks, including public open networks. Device warranty. By installing software on your device, you may void or impact your device warranty. You may not entail the support from the manufacturer of your device or network operator, if applicable. 3. Feedback. We provide the program to you so you can tell us about what you like, what you don't like, and what you usually like to see in the program. We provide comments, suggestions, or feedback about the program. Feedback. You grant Microsoft and its parts right to use that feedback in any way and for any purpose. You acknowledge that Microsoft will be collecting, using, storing, processing, and analyzing diagnostic, technical, error reports, crash dumps, usage, and other related from the devices that are running software as part of the program to help Microsoft improve our product services. If location service enabled the real-time geolocation device and location service queries may be collected as well. You also acknowledge that your feedback may be viewed by our program participants. Data collection. The program may automatically collect and provide data to Microsoft, which may include your personal information. We use this information with you as described below. We also may share certain data collected in connection with the program with third parties. For example, we may share data about the performance of a particular hardware or software component on your device with the manufacturer of that component to enable them to improve how their component works with Microsoft products and services. Microsoft privacy statement and this paragraph applies to data collected, used, and shared in connection with the program. Communications with you. Microsoft may use your contact information, 1, to communicate with you about your use program, and 2, to provide you additional information about the program and other Microsoft products and services. This contact may be email, SMS, instant message, voice chat, phone, and in the user interface or other means, and may include offers. You also may choose where you wish to receive personal email, SMS messages, telephone calls, and postal mail from Microsoft. Non-transferable. You may not transfer or share the software-related documentation materials you receive from Microsoft part of your participation in the program, unless otherwise agreed or permitted by Microsoft or accepted in the laws where you live, or if a business, by a principal place is located, permit this even if our agreement does not. Opt out. If you change your mind about the participant program, you may voluntarily opt out at any time. To stop getting Windows Insider emails and Windows 10 Insider preview builds, you can unregister and leave the program. To leave the program, please visit this page. If you'd like to just stop getting Insider preview builds, you can unenroll on your device, but stay registered to keep getting email updates from us. Termination. Microsoft reserves the right to terminate access to any or all of the program at any time without notice for any reason whatsoever. Termination of your use of or access to the program, or the termination of this agreement, terminate your right to possess or use any program, and you must delete all copies of software content and other materials provided as part of the program. Sections 9, 10, 11, 12, 14, and 15 survive termination of this agreement. 9. Additional terms. The following additional terms also apply to the program. To the extent any additional terms conflict with this agreement, the agreement will Microsoft software license terms. Any software license terms for software or any other software applications provided under the program will apply to those specific software applications. Third-party programs. The software may include third-party programs that Microsoft, not the third party, licenses to you under this agreement. Notices, if any, for the third-party program are included for your information only. 10. Reservation of rights. Microsoft may have patents, patent application, trademarks, copyrights, or other intellectual property rights covering subject matter in the program, except as is expressly provided in any written license agreement for Microsoft. The furnishing of this program does not give you any license fees, patents, trademarks, copyrights, or other intellectual property. Microsoft reserves the rights not expressly granted under this agreement, and no other rights are granted under this agreement by implication or estoppel or otherwise. Warranty. Microsoft and our affiliates, resellers, distributors, vendors, and partners make no warranties, expressed or implied, guarantees or conditions with respect to the program services or your participation in the program. You understand that use of the program is at your own risk, and that we provide the program on an as-is basis with all faults as available. You bear the risk of using this program. To the extent permitted under your local law, we exclude any implied warranties, including for merchantability, satisfactory quality, fitness for a particular purpose, workmanlike effort, and non-infringement. You may have certain rights under your local law. Nothing in this agreement is intended to affect those rights, if they apply. Damages. If you have any basis for recovering damages related to the program, you agree that you exclusively remedy is to recover from Microsoft or any affiliates, resale distributors, third-party app and service providers, partners, and vendors. Direct damages up to the amount that you paid for the program or up to $10 USD if you acquired the program for no charge. You cannot recover any other damages or losses, including direct, consequential, lost profits, special, indirect, incidental, or punitive damages. These limitations and exclusions apply even if this remedy does not fully compensate for any losses or failures if its essential purpose or if we knew or should have known about the possibility of damages. To the maximum extent permitted by law, these limitations and exclusions to anything or any claims related to primary participation in the program. 13. Updates to agreement. From time to time, we may change this agreement. If we do, we'll notify you by posting a notice on program website or through the following means. The user interface software and an email notification, instant message, or for a reasonable method. Use the program after the date the change becomes effective will be your consent to change terms. If you not agree to changes, you must stop using the program. I recommend visiting the program website at least once every 30 days to check for potential notice of changes. 14. Applicable law. The laws of the state or country where you live, or if a business, where your principal of place of business is located, govern all claims and disputes concerning the program services, including software participation in the program, and this agreement, including breach of contract claims and claims under consumer protection laws. Under competition laws, implied warranty laws for unjust enrichment, and in tort, regardless of conflict of laws principles. In the United States, the Federal Arbitration Act governs all provisions relating to arbitration. 15. Disputes. Binding arbitration and class action waiver if you live in or are a business with your principal place of business in the United States. We hope we never have a dispute, but if we do, and we agree to try for 60 days to resolve it informally. If we can't, you and we agree to a binding individual ambition for the American Arbitration Association (AAA) under Federal Arbitration Act (FAA), and not to sue in court in front of a judge or jury. Instead, a neutral arbiter will decide, and the arbitrator's decision will be final, except for limited right of review under the FAA. Class action lawsuits, classified aberrations, private attorney general actions, and any other proceeding where someone acts in a representative capacity are not allowed, nor is combining individual proceedings with the consent of all parties. We are and us includes Microsoft and its affiliates. Disputes covered everything except IP. The term dispute is as broad as it can be. It includes any claim or controversy between you and us concerning disagreement, the software, any advertising, marketing, or communications, any program, services offered or sold, or you participated in a program under any legal theory, including contract, warranty, tort, statute, or regulation, except disputes relating to the enforcement or validity of your licensors or licensors' intellectual property rights. Mailing notice dispute first. If you have a dispute on our customer services representatives can resolve it, send a notice dispute by U.S. mail to Microsoft Corporation, ATN, CLA Arbitration, Microsoft Way, Redmond, WA 98052-6399, USA. Tell us your name, address, how to contact you, what the problem is, and what you want. A form is available here. We'll do the same if we have a dispute with you. After 6 days, you or we may start a small arbitration if the dispute is unresolved. Small claims court option. Instead of mailing us dispute, you may sue us in small claims court if you meet the court requirements in your country of residence, or if your business, your principal place of business, or King County, Washington, USA. Arbitration procedure. The AAA will contact any arbitration under its commercial arbitration rights, or if you are an individual and use the program services, including any software for personal or household use, or if the value of the dispute is $75,000 USD or less, whether or not you are an individual or how you use the program services software, it's consumer arbitration rules. For more information, see adr.org or call 1-800-778-7879 to start an arbitration. Submit the form available here to the AAA and mail copy to us. If it's been line $25,000 USD or less, any hearing with will be telephonic unless the arbitrator, I'm not exactly arbitrator, I'm not exactly sure how to say that, finds good cause to hold an in-person hearing instead. Any in-person hearing will take place in your country of residence, or if a business, your principal place of business, or Key County, Washington. You choose. The arbitrator may award the same damages to you individually as the court could. The arbitrator may award declaratory or injunctive relief only to you individually, satisfy your individual claim. RAA rules the arbitrator rules on his or her own jurisdiction, including the arbitrability of any claim, but a court has exclusive authority to enforce the prohibition of arbitration on a class-wide basis or in a representative capacity. 3. Arbitration fees and payments. Disputes involving 75,000 USD or less. We will promptly reimburse your filing fees and pay the AAs and arbitrators' fees and expenses. If you reject our last reinstatement offer before the arbitrator was appointed, your dispute goes all the way to the arbitrator's decision called an award. And the arbitrator awards you more than this last written offer. We will 1. Pay the greater award or 1,000 USD. 2. Pay your reasonable attorney's fees, if any. And 3. Reimburse any expenses, including expert witness fees and costs, that your attorney reasonably appears for investigating, preparing, and pursuing a claim in ambition. 2. Disputes involving more than 75,000 USD. The AA rules will govern payment of filing fees in the AAs and arbitrators' fees and expenses. Must file within 1 year. You and we must file in small claims court or arbitration any claim or dispute except intellectual property disputes. See section 15.1. Within 1 year of when it first could be filed. Otherwise, it's permanently barred. 5. Rejecting future arbitrations. You may reject any change we made to Section 15 except address changes by sending us notice within 30 days of the change by U.S. mail and the address in Section 15.1. If you do, the most recent version of Section 15 for the change you rejected will apply. Severity. If any severability. If any part of Section 15 disputes binding arbitration and class action waiver is found to be illegal or unenforceable, the remainder in which will remain in effect with arbitration award issued before any court proceeding begins, except that if it's finding or partially illegality or unenforceability will allow class-wide or representative arbitration. Section 15 will be unenforceable as 30. 7. Conflict with AA rules. The agreement governs to the extent it conflicts with the AA's commercial arbitration rules or consumer arbitration rules. And that's it. I got done in 2 minutes and 9 seconds. And so yeah, that's it for this video. Bye.